You understand that you have an absolute right to have a jury come in and determine two things. The first is to determine if you're guilty or not. And then if they find you guilty in the case, you could leave your punishment up to that jury. If we go forward this way, you're leaving your punishment up to the court. And is that what you want to do?
Yes.
State tenders number 1 in each. As soon as it comes, oh, it's here. Let's get Michelle Cormier. There it is.
I'm gonna need maybe 20 or 30 minutes in sentencing.
Okay.
Probably 30, closer to 30, maybe a little bit.
We'll just make a note that we'll do it at 11. Do it on a different day. Yeah.
Yeah,
Okay. You're Michelle Cormier,
Yes, ma'am.
and will your client waive the formal reading of the indictment in each case?
yes, ma'am.
Ms. Cormier, in clause number 25, DCCR 1446, let's see, are we going on with the prior or just the,
With the prior judge.
okay. Let me, you're charged, hold on. You're charged with manslaughter from November 2nd of 2024. It's a second-degree felony. The indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, January 30th of 2013. And how do you plead to that charge? And are you pleading guilty freely and voluntarily,
Yes, ma'am.
and because you did what they've charged you with? And is that prior conviction true?
Yes, ma'am.
Okay. Sorry, it takes me a minute to get it pulled up. In cause number 25, DCCR 1447, you're charged with possession of a controlled substance, a state jail felony from October 30th of 2024. The indictment alleges you were previously convicted of possession of a controlled substance, a state jail felony, January 30th of 2013, in 2 different cases, or 3 different cases on that date. And what that means in that case is that would be enhanced to a 3rd-degree felony. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And are those prior offenses true?
Yes, ma'am.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, correct, in either of the cases. So I want to make sure you understand that you have an absolute right to have a jury come in and determine two things. The first is to determine if you're guilty or not. And then if they find you guilty in the case, you could leave your punishment up to that jury. If we go forward this way, you're leaving your punishment up to the court. And is that what you want to do?
Yes, ma'am.
State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Ms. Cormier is not competent?
No, ma'am.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done, and then we'll come back for that hearing. Anything that you think is important for me to know, get that information to Mr. Radford, and he will present it to me on your behalf when we come back.
Judge, we're gonna have some letters that I will submit to the court to supplement the PSI, and I will copy Mr. Coleman on those support letters.
Okay, sounds good. And if you'll just try to get those to the court that week before
Yes, ma'am.
The hearing, that would be great.
Yes,
All right,
ma'am.
thank you. You can go
Thank
back
you.
with the bailiff.
I'll be-
Yes, sir, thank you. Mr. Rojas, you have Adrien Banks. Morning.
Good morning.
Are we going on count one only?
Yes,
Or-
Judge, if we may, with the court's permission, this is basically a misdemeanor offense, but due to the nature of it, it's TDC.
Good morning. Are you Adrien Banks?
Yes, ma'am, I am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Banks, in cause number 25 DCCR 1432, you're charged with a third-degree felony offense of harassment of a public servant in count one of that indictment, and that is from September 1st of 2025. And how do you plead to that charge?
Guilty now.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Banks is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of, in count one, of harassment of a public servant, sentence you in accordance with your agreement. It was 2, right? To a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Raymond Sweet, Mr. Rojas. I feel like this may be my last one. I want to tempt it too much getting into.
Seven?
Good morning. Are you Raymond Sweet? Yes, ma'am. And Mr. Sweet, in cause number 25 DCCR 1531, you're charged with a first-degree felony offense of burglary of a habitation with intent to commit another felony, and that's from August 22nd of 2025. Your indictment alleges you were previously convicted of burglary of a habitation May 28th of 1987, and also burglary of a vehicle on that same date. And then after those were final, you were convicted of robbery April 20th of 1988, and also burglary on that same date as well. And then after all of those were final, you were convicted of aggravated assault of a correctional officer June 8th of 1992. What that means is that if you go to trial and you're found guilty and those prior offenses are true, the range of punishment in your case would be between 25 years and up to 99 years or life. Do you understand? And I have a plea bargain rejection here on the tablet that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 30-year term in prison. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I'll get that done. I do want to make sure, Mr. Smith, is there any reason to believe that there's any other evidence or that offer would change?
It's not going down.
So I want to make sure you understand that I will not accept that offer after today. If you change your mind and you want to enter a plea of guilty, then it would be to something different or open to the court. Also, so do you want to go forward with trial?
Yes, ma'am.
Okay. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint someone else today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Rojas, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Yes, sir. Robert Felix, what are you going to do on
Hey,
him?
can we hold on for a little bit? We're
Yeah,
trying to get over the
that's good.
questions.
And then what about, we got an incompetent. Let's see, I think I can get that done maybe, well, I hate to get in the middle of it. I feel like surely he's gonna be soon. Quentin Sells, let's get him ready real quick. See if I can do that. I know. Yes. You're probably doing it. Maybe that's okay. Yeah, I just want to have make sure it's on there. We need bank. All right, are you Quentin Sells? So, Mr. Rojas, you've been appointed to represent Mr. Sells. Is there any reason to believe that the person standing before me is not Mr. Sells?
No, Your Honor.
And so I'll take judicial notice of that, as well as the court's file, including a report. Mr. Sells was evaluated for competency to stand trial by Dr. Hamza. I have received that report dated November 14th of 2025. The finding is that Mr. Sells is not competent to stand trial at this time. Is there any other evidence with regard to competency?
No, Your Honor.
Not from state here.
Then at this time, based on that evaluation, I am going to find that Mr. Sells is not competent to stand trial. I'm going to order inpatient treatment at the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report from that facility. He can go back with the bailiff.
No, go on. I'm trying to get.
We're gonna get
I'm a
you,
lot of credit.
yeah, we're gonna get you some help, and then you can come back and take care of your case, okay? Go back with the bailiff, okay?
Then for what?
Right there, go back, go to the back, okay? Go to the back.
I'm outside.
See who's got it. Ms. Holmes, you're working on some stuff, it looks like. Let's see, got a couple on Mr. Lewis, he might be working on those. So if nothing's ready, I'm gonna go ahead and just take a break, and then I'll be back in hopefully in about 15 minutes again.
The courtroom unfolds like a series of crossroads, where every defendant faces a moment that could redefine
All right, are you
their
Quentin
future.
Sells?
Judge Simpson presides
So,
with
Mr.
calm
Rojas,
authority,
you've been appointed to represent
moving from
Mr.
case to
Sells.
case,
Is there any reason to
each one
believe that
heavier than the last.
the person standing
Eric
before me is
Gibson's
not Mr.
appearance comes
Sells?
first.
And so I'll take
Charged
judicial
with
notice
multiple
of that,
counts,
as well as the
including
court's
sexual
file,
assault. His
including
case is
a
reset.
report. Mr. Sells was
temporary
evaluated
pause
for
before
competency to
consequences
stand trial by
inevitably
Dr.
return.
Hamza.
Next
I
comes
have
Cash
received that
Party.
report
Already on
dated
probation and
November
now
14th
facing
of
a new indictment
2025. The
involving
finding
injury
is
to
that
a
Mr.
child.
Sells is not
Pregnant,
competent to stand trial
unemployed,
at this
and
time. Is
emotionally
there any
strained.
other evidence with
She
regard to
testifies about her
competency?
finances,
Not from state
her
here.
children,
Then at this time, based
her
on
attempts
that
to comply with
evaluation, I am
CPS
going to find that
requirements.
Mr. Sells
The
is not
judge
competent to
listens
stand
carefully,
trial. I'm
balancing
going to
compassion
order
with caution. Bond
inpatient
is
treatment at
granted,
the
but at a
appropriate
steep
facility
price.
for a period of not to
Strict
exceed
conditions are
120
imposed,
days from the day
including
he
no
gets to that
unsupervised
facility,
contact with
and then
children.
we'll await a
A
report
reminder
from
that
that
freedom in
facility.
this
He
courtroom
can go back
is
with the
never
bailiff.
unconditional.
No, go on.
As proceedings continue, Calvin
We're gonna
Hawkins
get you-
seeks relief from a high
Yeah,
bond,
we're gonna get you
only
some
to be
help, and then
delayed
you
by
can come
missing
back and
paperwork.
take care of your case, okay?
Another example of how
Go back with the
procedure
bailiff,
can quietly
okay?
decide a person's fate.
Right there, go back, go to the back,
Shifts
okay?
Sharply with
Go
Braxton
to,
Hughes.
go to the back.
His burglary case opens a raw conversation about addiction, accountability, and a criminal history stretching back decades. Hughes speaks of sobriety and faith, but the judge confronts the record.
Ms. Holmes, you're working on some
Revoked
stuff, it looks
probations,
like.
repeated failures,
Let's
and
see,
broken chances. Despite brief sympathy, the
Had a
sentence
couple
is
on
firm.
Mr. Lewis. He might be
4
working on
years in prison.
those.
The courtroom opens
So
in
if
procedural
nothing's ready,
calm,
I'm going to go ahead and
but
just take a
beneath the
break, and then I'll be
routine lies
back
the
in
weight
hopefully
of
about
irreversible
15
choices.
minutes again.
Judge Simpson moves case by case with steady authority, each defendant standing at a crossroads between accountability and consequence. First is Michelle Cormier, facing the gravity of a manslaughter charge alongside a controlled substance offense. Her voice is quiet, her answers short, as she admits guilt freely, acknowledging both her actions and her past convictions. The judge's tone is firm yet measured, ensuring Michelle understands.
This is not just a case. This is a fight for justice, where one question from the judge can change a life forever. The silence of the victim, the arguments of the lawyers, and the verdict that decides the truth. Welcome to Court and Courtroom, where every case reveals a new truth, and every truth leaves a lasting impact.